Today I want to go over with you section 32-5A-191B, which most people refer to as under the age of 21 DUI. Others refer to it as baby DUI, depending on where you are and who you're talking to. The purpose of that section is to cover someone who is under the age of 21 years. And basically the section says that a person who is under the age of 21 years shall not drive or be in actual physical control of any vehicle if there is 0.02% or more by weight of alcohol in his or her blood. That is interesting that the section allows a 0.02 because obviously someone who's under 21 presumably should not be consuming alcohol anyway. I think it goes back to the legislature's distrust of any breath testing device, so that someone is not eating bread or using mouthwash or some other way that would increase the blood alcohol content, and they basically built in the 0.02 because of the inaccuracy of the breath testing device. The section of the code that deals with this goes on to say the Department of Public Safety shall suspend or revoke the driver's license of any person, including but not limited to, and it goes through and lists a juvenile, a child, someone who has been determined to be a youthful offender, etc. So that further solidifies the fact that a youthful offender designation or any other designation that might seal a record for someone who is underage, that is not going to protect them from a driver's license suspension under this section of the code. It goes on to say exactly what happens whenever someone's blood alcohol content from the Draeger breath testing device is between 0.02 and 0.08. Basically, it goes through and says if on a first violation of this subsection of the 32-5A-191B, it goes over and basically says the only penalty that shall occur is the person's driver's license or driving privilege shall be suspended for a period of 30 days in lieu of any penalties provided in subsection E of this section. Subsection E goes through the penalties for a first offense DUI under normal circumstances. It goes on to further state there shall be no disclosure other than to courts, law enforcement agencies, and the person's employer by any entity or entities, and essentially they're prohibited from providing any information, documents, or records relating to the person's arrest under this subsection of the code. The important point to note here is if you have a DUI charge and you're under 21, it's very important that you are represented by competent counsel so that all options for you can be explored. Many times if someone is under 21, submits to the test, and the result is 0.08 or greater, then they will be charged under 32-5A-191A, whether it's A1 or A2. And it's important to note that because depending on the court that you're in and depending on the issues that come up in the case, it sometimes is possible to have charges dismissed, outright, reduced, or it is possible that the charge could be reduced to a DUI under subsection B if that is an option that you as the client or the defendant chooses to accept, depending on what the tribal issues in the case are and what any other issues that are out there how viable those issues are to providing you with a legal or factual defense in court in order to win your case at trial. It's also important to note that this supposedly would only apply on a first offense as far as the 30-day requirement for the driver's license in lieu of any of the other penalties. It's also important to note that per the statute, if someone is under 21, it is between 0.02 and 0.08, then presumably they would not be required to attend the court referral classes, which are drug and alcohol classes. They would simply suffer a 30-day license suspension, would not have any fines, any costs, or any other repercussions related to the conviction under 32-5A 191B. My name's Joseph Kreps. I'm a DUI defense attorney in Alabama. If you've been charged with DUI, whether you're under 21, refused the test, your result was 0.02 to 0.08 or greater than 0.08, we want to talk to you to begin the discussion with you about your case, to help you learn more about your case, and to provide you with the information and the knowledge necessary to make the determination to hire us as your attorney to represent you on your DUI charge. Section 32-5A 191B is sometimes a great option for a defendant, depending on how they're charged and depending on the issues in the case. Our goal in every DUI case is to resolve the case in a way that avoids a conviction, any conviction under any section, and provides you with the proper plan and the proper guidance and the process so that you can do everything within your power to get a great result on your DUI charge in Alabama, one that is a win-win for everyone, that allows the case to be litigated and tried if needed, and if there are other options available to have your case dismissed by agreement, those will be explored as well and presented to you so that you can make an informed decision about how to handle your case. You can reach us at 866-348-2889. Thank you very much.